think we should begin our webinar, although there may be still people joining, and we know that we've got delegates from something like 20 countries around the world who are joining us today. So let me say welcome to this Art Law webinar, which is being staged by the RDR Group. And our panel is going to discuss claims for the return of World War II art and other property. My name is Anthony Connerty. I'm a barrister in practice in London, specialising in international dispute resolution. And I'm pleased to welcome you to this webinar on behalf of the RDR Group. Let me tell you a little about the group. The group was launched at a reception in the Houses of Parliament in April 2008. And the guests included members of Parliament, Commonwealth High Commissioners, representatives of the Corporation of the City of London, UNCTAD in Geneva, and the Energy Secretariat in Brussels. And the guest speaker at that reception was Baroness Scotland, who was the then UK Attorney General for England and Wales. Now, the group is a not-for-profit organisation. It's not an arbitral institution, and we don't appoint arbitrators. The group is based in London at the International Dispute Resolution Centre in Fleet Street, close to the law courts in London. The members of the group are arbitrators, lawyers, and other professionals from some 20 countries around the world. The group membership includes a panel of consultants who are not necessarily lawyers, but who specialize in areas which are relevant to international dispute resolution. And members of the group have sat as judges and arbitrators in the International Court of Justice and in the Permanent Court of Arbitration in The Hague and in the International Tribunal for the Law of the Sea in Hamburg. And members also sit as arbitrators and act as advocates in the world's major commercial centres. Now, we have recently launched a new website, rdrgroup.global, and the purpose of that website is to act as a platform for our series of webinars. We started last month with an energy webinar. This art law webinar is our second, and on the 23rd of July, we are staging a China webinar, and further webinars are planned. Now, I'm now going to hand over to Tom Christopherson, who will moderate the webinar. Tom is a member of the IDR Group's art law section. He is a solicitor and art law consultant. He acts as a legal consultant to the law firm Constantine Cannon and to Canvas Art Law and to Bonham's Auctioneers. And Tom is a consultant counsel at Sotheby's. He was subsequently head of art law studies at Sotheby's Institute of Art. Tom, over to you.
Welcome to everybody. Good morning or good afternoon, depending on where you are. So today we're going to spend an hour and a half or so looking at the resolution of disputes concerning art and other assets that were seized or looted, largely, though not exclusively, by the Nazis in the period 1933 to 1945. So quite a specific remit in that regard. And as we'll no doubt hear during the talks that we've got to come, some of this art was destroyed by the Nazis because it was deemed to be degenerate, is the phrase they used, and not worthy of the Nazi state. Other works of art were retained for private and institutional collections in the Third Reich, and many, many more items were sold on through compliant dealers and auction houses at the time. And through that route, found their way into the international art market and into ultimately the innocent ownership on and possession of both private collectors and public institutions all around the world. And in many cases, they're still there. After an initial burst of activity immediately after the war, this issue tended to fade behind all the other huge priorities that people had. And for the lawyers amongst us, limitation periods under various jurisdictions tended to run out as time passed. And that made it harder and harder for the dispossessed to make a claim, assuming they could work out who that claim should be made against and where, given the wide dispersal of the art that I've described. And this issue rather fell from view and began to re-emerge in the 1990s, partly driven by the amount of information that became available after the fall of the Berlin Wall. So a new impetus was given to this age-old problem. And that process, you might say, culminated in the Washington Conference on Holocaust-era assets, which was held in December 1998. And that set out 11 non-binding principles by which issues around restitutions of Nazi-era looted art might be addressed. And in a sense, that conference and those principles form the background to much of what we're going to discuss today. And I'm delighted to say that we have a fantastic and distinguished panel of experts to provide different viewpoints on these issues and how they have been rolled out in really since 1998. And we have Harvard Mbe, Dr. Jacques Schumacher, Isabel Von Glitzing, and His Honor Judge Tony Baumgartner. They're going to speak for 10 minutes or so each in that order, and I will introduce each in turn when we come to their session. As you will see, they are all enormously experienced in this area, in many respects from different angles. So I hope that during the course of the next hour or so, we will have different perspectives on what have been some extremely difficult issues, legal issues, but much wider than legal issues, ethical and moral issues to be resolved, quite often between competing parties who have their own very clear rights and claims to the objects under dispute. So the question we're going to look at is, how does dispute resolution work in this particular field of 1933 to 1945 provenance and ownership disputes? And we'll be very welcome to take questions. If you'd like to put questions into the chat panel, then we will address them after the individual discussions. And I hope and look forward to hearing your questions, a wide range of questions then. And in the event we don't cover all the questions in time, our panelists are very happy to respond to questions afterwards. So it's a wonderful opportunity, I have to say, for you. And there is a website on the IDR Group website, info@idrgroup.global, and we will give you that again. And if you find you haven't had time to make your questions in this session, submit a question to there afterwards, and we'll do our best to give you an answer. Right, let's start with Harvard Mbe. Arthur is an extremely distinguished arbitrator with several decades experience in the area of dispute resolution in this field, and in fact in the center of dispute resolution in this field, including involvement with the International Commission on Holocaust-era insurance claims. That was in the early years of the new millennium, and also as the long-standing chairman of the UK government's Enemy Property Compensation Advisory Panel, which was founded in 1999, a date you will see immediately follows shortly after 1998 in the Washington Principles. Arthur's going to be talking about slightly wide, he's going to set the scene for us in a slightly wider area than just art, because it's easy for those of us in the art world to forget there are plenty of other assets to deal with under this heading, as well as works of art. Arthur, over to you.
I deal mainly with financial compensation, and I'd like to mention at the outset that there are many emotional aspects to financial compensation which play an important role to the recipients of the compensation. For example, a recipient of compensation feels that there's a sense of justice that at last has been done, and that it gives closure to the experience of suffering that the individuals have had. And also they are pleased that there is some public official recognition of the suffering experience within their family. It's also a form of family remembrance of events that happened within their family, probably to their parents or their grandparents. And finally, for the elderly claimants, and a majority of the claimants tend to be elderly, the financial compensation provides assistance for their current social and medical needs. So that's always an important consideration from them. Now I'm going to look at a small number of compensation schemes which relate to the fact that before the Second World War, many families understood what was about to happen, and they placed money in banks overseas as a form of financial security for their families. Prominent amongst them were placing funds in Swiss banks and also in British banks, but there were several other countries in which people put their monies as well. Similarly, many families, particularly in East Europe, used insurance policies as the standard form of savings for the family. And they never got their money back. So I'm going to look at just a few examples of the schemes that have been in existence. First of all, in relation to the Swiss banks, compensation was paid through a team of arbitrators, and the amounts that were paid were based on the book value as at 1945, at the end of the war, multiplied by 10, which reflected the long-term Swiss investment rates. So that fixed the amounts that were paid. The United Kingdom panel of arbitrators dealing with this issue cover bank accounts in the UK that were placed before the war by residents of enemy or occupied countries that were seized by the British government to ensure that the monies were not taken by the enemy powers who could use it for the benefit of economic warfare. And the British system is particularly generous because it takes the original value that was confiscated and is multiplied by the increase in inflation since that time. So, for example, a German family which placed assets in the UK in their bank before the war of £1,000 sterling would now receive in compensation in excess of £52,000. So if more was put in, then the figures, of course, go higher. The International Commission for Holocaust-era insurance claims either pays the precise amount of the value of the insurance policy, or if the amount is not known, there is a standard modest payment of usually £5,000, but occasionally, sorry, $5,000, but occasionally $10,000. Now, as I'm talking mainly to an audience of lawyers, I thought I'd refer to the standard of proof that is adopted in these various schemes. The key thing, of course, is to demonstrate your ownership of the asset or the entitlement to the ownership if one is an heir. When these schemes were started, there were still many original owners who were alive, if not their family would claim, and now virtually everybody who is claiming is an heir of the original owner. With the Swiss bank accounts, a fully documented claim, that is where the claimant was known and the amount in the bank was known, the average payments work out at $185,000. And where the claimant is known, but the amount in their bank account is not known, the payment is less, $125,000. And there was a special rule that if the claim was plausible on the basis of it's more likely than not that the individual did have a bank account, but it's undocumented, there's a modest payment of $7,250. The insurance payments were based on a very relaxed standard of proof, but most of the documentation was, or a lot of the documentation was lost. So reliance can be placed on letters, diaries, anecdotal evidence. Yes, I know that man, he was my neighbor, and I remember that every month he had a visit from an insurance agent. The standard can be even more relaxed because there was a level of plausible evidence. It's more likely than not that the individual had an insurance policy. And for the British system of payment, there's a requirement to prove that Nazi persecution occurred to the original owner, or if an heir, to the claimant, must demonstrate ownership of assets. And in the case of heirs, the entitlement through wills or a clear evidence that he would have inherited in the absence of other family members who had died. We have a very relaxed time for supplying evidence. If we require further information, we're happy to give the claimant as long as he or she needs to acquire the additional evidence. So we're very relaxed in that way. And we do have a first-class appeal process in existence for those who are dissatisfied with the outcome of their claim. And finally, we also opened many deposit boxes that were held in banks. And I'm glad to say that in one box, we found a significant item of art. We got it valued and were able happily to return it to the original owner and his family. And having mentioned art, this is an ideal time to hand over to the speakers dealing with art. Thank you very much.
Thank you, Arthur. That was very neat. And I think, yes, thank you also for painting the background to all of this. So, what do you say about the resolution of financial disputes is obviously equally true of resolution of ownership disputes of works of art. It's not
Yeah.
just about the art. It's about how the art was lost, who the art was lost from, and that feeling of closure and justice.
Yes.
And actually, that makes these cases sometimes all the harder to to fix, because of these enormously powerful factors that run throughout. And as you say, that's a very neat moment, Arthur. Thank you very much. To move on to our second speaker, Isabel Von Glitzing. Isabel is a leading independent provenance researcher in this field, so we're now focusing exclusively on the art. And Isabel has worked with both well-known art collections and major auction houses. She actually worked for 10 years on the floor above me, actually, at Sotheby's as the senior restitution specialist in both London, based in London, Belgrade, and Frankfurt. And Isabel went on to establish the Provenance Research and Art Consulting firm in 2012, which continues to provide advice on the practical, technical, and legal aspects of dealing in cultural goods that have been lost due to Nazi persecution. Isabel has also been appointed a provenance expert by the Court of Arbitration for Art in the Netherlands, and I know has conducted extensive provenance research into a particular substantial private collection and this is, I think, going to be an increasingly common theme, to actually review a collection to see whether there are objects in there of, should we say, uncertain provenance that need to be fully resolved. And Isabel's going to sort of show us, I think, a little bit about how this is done in practice. If you think you've got a potential claim, how do you follow it up? What sort of evidence do you find? Where do you find it? And alternatively, if you think you might be on the end of a potential claim, again, how do you carry out the same research? And Isabel, I see you've got your slides up and running, which is great. Arthur, could I just ask you to mute your PC so that we limit our, it's very quiet, I have to say, but it always improves the reception if we do that. Isabel, over to you.
Thank you very much, Tom, for the introduction, and many thanks to the IDR group for inviting me to speak here and to be part of this illustrious panel. As you can see from my cover slide, I'm going to approach the topic from a very practical point of view, and I will explain the research process which can help to find out whether a work of art has been wrongly dispossessed between 1933 and 1945, both from the perspective of the current possessor and potential heirs of former owners. Although many families have been compensated for their lost property, including art collections after the war, the topic has come up again in different contexts, as just explained by Arthur and Tom. Tom also talked already briefly about the Washington Principles and the Washington Conference, of course. And I just want to show you 3 principles which are specifically relevant for our context today. Number 1 is about the identification of problematic artworks. This is my part today. Principle number 8 is mentioning just and fair solutions, which should be achieved between potential heirs and current possessors. And principle number 11 is suggesting to create national alternative dispute resolution bodies. And these principles only apply directly to public institutions, but they also have a serious impact on the art market. And there are also, as Tom already mentioned, there is also an increasing number of private collectors who are starting to look into the provenance of their objects as recommended in the so-called Terezin Declaration, which was adopted during the follow-up conference in 2009 in Prague. These principles are ethical principles, legally not binding, which means that they usually not lead to any legal disputes. So far, France, the Netherlands, the United Kingdom, and Germany have created national panels to resolve potential ownership issues implementing principle number 11. So let's assume you are a private collector. How can you find out if any of your artworks have been wrongly dispossessed during the Nazi period? You need to know, first of all, that due diligence usually applies to unique artworks created prior to 1946, who changed hands after 1933 and have not been restituted to the original owner after the Second World War. On this slide, you can see some possible steps to be taken to fill potential provenance gaps, always depending on the individual case. The research approach is very similar for an heir who might look for dispossessed artworks. So, first of all, take stock. What kind of documentation do you have in your archive with regard to the history of your artwork? This could include correspondence, photographs, inventories, invoices, and so on. Arthur has also just explained some of the categories of documentation, which might give some clues for further research. The physical examination of your artwork is also a very important step. You have to take a close look at the object itself, since there could be labels, names, or stamps, for example, that might shed further light on the ownership history. The problem is, of course, that very often paintings, for example, have been relined and there's nothing relevant on the back anymore. If there is a catalog raisonné for the relevant artist, you have to consult it first of all. The problem is that information given in catalog raisonnés is very often not accurate. Was the work ever included in an exhibition, and is it mentioned in the catalog? You might be able to identify the lender, which also might help to give further research clues. The same applies to auction catalogs, which can potentially reveal the consignor and buyer, which can also help you to take your research further. If there is red flag names. If there are so-called red flag names in the provenance, more research is needed and may lead to the conclusion that the then owner was unlawfully deprived of the artwork by the Nazi regime. Red flags include, for example, the names of families known to have been persecuted, as well as individuals, agents, dealers, and auction houses involved in looting or trading Nazi dispossessed art at the time. Finally, that you see on the right, there are many different databases that need to be consulted. For example, the German database LostArt.de, containing entries of potentially problematic looted artworks. To give you some practical examples, you might recognize this Liebermann painting. It's called Two Riders on the Beach, and it was found in the apartment of Cornelius Gurlitt, the son of the art dealer Hildebrand Gurlitt in Munich in 2014. Restituted to the heirs of the Jewish art collector David Friedman from Breslau, it was sold at Sotheby's for a record price. This is an example where the information provided in the relevant catalog raisonné here from 95 did not contain accurate information. Here you can see that it says David Friedman until 1928, and then Hildebrand Gurlitt only from 1954 onwards, which means that there is a huge provenance gap for the relevant time. The painting was, in fact, as we could find out through our research, with David Friedman, who lost his collection due to Nazi persecution until at least 1939. Gurlitt acquired it already in 1942 from the National Museum in Breslau, and it was returned to him after the war from one of the so-called collecting points established by the Allies after the war. Here you can see the backside of the painting, and here, the numbers 1930, which you will also recognize on the property card from the collecting point in Wiesbaden on the top. Yeah, and also you see here that the painting, that Gurlitt is mentioned as the depot possessor, and the painting was first returned to him and then recently to the family of the original owner. This is another example of a silver cup which I researched on behalf of a private collector. It turned out to have been part of a forced sale at the auction house of Paul Graupe in Berlin from the collection of Emma Butke. Both Butke and Graupe, and also of course Gurlitt and Friedman, are all so-called red flag names and need further research. Butke, the name might sound familiar to some of you, since the UK Spoliation Advisory Panel also dealt with some Meissen objects from the Butke collection, which were returned to the US by the V&A. This auction took place after Emma's death. She changed her will to help persecuted relatives instead of giving her collection to German museums as initially planned. So here you see the auction catalog from 1937 and our object down here. And I have to say that this is a rather dangerous silver cup, because you have to, you put wine in it and you have to empty it as long as the windmill is turning, and you cannot put it down before it is empty. So here you have a better image of, it's a beautiful silver cup. And on the right-hand side, you see the registration on this German database Lost.de, which was made in 2011. I'll stay here. So if there's evidence that an object has been looted and not given back to the original owner, the next steps depend on the current whereabouts of the artwork. For a private collector, like here, such a tainted work has almost no commercial value, since it would, for example, not be offered for sale by a reputable dealer or auction house. It is therefore advisable to reach out to potential heirs, which can prove again as a very difficult undertaking, to find a solution which is acceptable for both parties. In the case of the windmill cup, a deal was done with the heirs based on the consideration that it was formerly in a Jewish collection in Germany, that the sale took place under duress at the Aronized Jewish auction house Paul Graupe in Berlin in 1937, that the heirs were deprived of the sale proceeds and never compensated for the loss. It was then in a private collection in Switzerland for some time and acquired by my client in good faith in 2009 at TEFAF in Maastricht with an unknown provenance. The lost art entry dates only from 2011 and was deleted after a settlement with the heirs was reached. They were compensated, and this cup is still in the collection. I chose this example because the situation of works in private collections also needs to be considered, and settlement agreements for works in public collections often set problematic precedents for works in private hands. Jacques Schumacher will now explain some of these aspects from a museum's perspective. Thank you very much.
Thank you very much, Isabel. That was very interesting. A very quick view of the sort of practical aspects of how to do this. It is a very complicated process, and it'll be very interesting to hear, in a sense, the other side of that from Jacques, who's looking at exactly the same issues from the perspective of an institution. Jacques, do you have some slides?
I do. They should be on the screen now.
There we are. Well, then over to you.
Thank you very much, Tom. When we think of Nazi looted art, it's immediately obvious to us why this is a problem for German museums, because we know that German museums were the direct beneficiaries of the Nazis' looting of art, of the systematic campaign of persecution and dispossession against the Jews. And what you can see here behind me is an index card that was created by German curators in Frankfurt for an object which was forcibly sold in November 1938 during the events known as Kristallnacht. And you can see here that the curators at the time saw no reason to lie about the provenance of this object. So they recorded that they acquired it in November 1938 from the Goldschmidt-Rothschild collection. They never thought that Germany would lose, that there would be a war, and they didn't know that Germany would lose it. But because of these records, the piece was identified after the Second World War and then restituted to the family. And it is now on display at the Victoria and Albert Museum as part of the Concealed Histories display. But what I want to explore with you today is the question why Nazi looted art is not just a problem for museums in Germany, Austria, or countries which were occupied by the Nazis, but also for countries that fought to defeat Hitler and his regime. And to understand why such objects ended up in the collections of British museums, it's important to look at the questions that curators asked when they added objects to their collections. And what you can see here is a typical entry from an acquisition book at the V&A. And what you can see here is that, like the German curators, the British curators recorded from whom they had received the object, in this case from a Mrs. Dickinson. And this is in fact the last acquisition prior to the outbreak of the Second World War. And what it shows you is the traditional function of provenance research, which was not about establishing an unbroken chain of ownership or to identify potential problems, but it was supposed to increase the value of a piece by highlighting sort of particularly famous previous owners, aristocrats, or particularly influential collectors. And this information then allowed the curators to argue that the piece was worthy of the inclusion in the museum's collections. This man on the screen behind me is called John Hayward. He was a member of the unit known as the Monuments Men, and he played an instrumental role in the restitution of Jewish libraries, which the Nazis had confiscated all over Europe. And you can see him here at the Nazi think tank, where he sort of looks at books that had been confiscated. And he became a curator at the V&A in 1947. And we would now certainly expect that when he joined the museum would have changed the questions it asked about provenance, because this is a man who was acutely aware of all the mechanisms involved in the dispossession of the Jews. And he was also somebody who knew that many artworks were not recovered and were not restituted after the war. But if we look at his acquisitions at the V&A, we can see that, like all the curators before him, he also only recorded the name of the person who gave it to the museum, and in general, very, very limited information about the provenance. He didn't ask any specific questions about the Nazi era. And I think it's very important that we don't rush to judgment about what to us now looks like a dramatic and almost intentional oversight, but that we try to understand why this was the case. And I believe that Tom has already, if I remember it correctly, Tom mentioned that the society was eager to move on after the war. But it is also important to realize that it was very, very difficult to get the answers to these questions at the time, because the archival records were not available and Jewish families had only just embarked on the restitution process. And this practice remained unchanged for 50 years. And in the case of the V&A, this means that we have hundreds of thousands of objects in our collections which were acquired from 1933 onwards and after the war, where we know very, very little about their provenance. And it was only in the late 1990s that this practice changed. And I'm very grateful to Arthur for contextualizing this with broader compensation efforts, because it is we always like to treat art as something special, but in the discussions at the time, it was just one of many Holocaust era assets which had not been recovered and restituted after the war. And what made a particularly big impression on British museum directors at the time was when the director of the Met was asked to testify before the House of Congress in Washington, where he had to explain the difference between the storage rooms of his museums and Swiss bank vaults. And he said, there's a major difference between museums which display, publish, and invite dialogue on their collections and other kinds of institutions, such as banks, which recently have been shown to have hoarded for half a century the spoils of war and genocide, not in the open as with works of art, but in the darkness of total secrecy. And Isabel has already introduced you to the Washington principles, which really transformed the idea of what provenance was for. It was no longer seen as something that curators use to tell interesting and fascinating stories about the history of collecting. It really became a forensic tool to rectify past injustices. And if you look at the internal records of Britain's museums, it becomes very clear that they were determined to confront the provenance of their collections and that they wanted to restitute pieces which were looted under the Nazis to the families of the victims. And in Washington at the conference, they heard that the museum's own records would provide many of the answers. And they were very motivated when they returned. But when they actually started to look at their collections, they started to realize that their own records actually told them very, very little about the provenance of their collections. And this really highlights what I think is the fundamental problem, the fact that the connection between the records that tell us about the dispossession of individual Jewish families to the museum records is broken. And Isabel has highlighted the research methods, which are essentially the same for a museum. Another major problem and a huge embarrassment for Britain's museums was that when such objects were discovered, national museums were unable to return them to the families because of the laws that govern museum collections. And Tony Baumgartner is going to talk about how this law was changed and the Spoliation Advisory Panel, which was set up to resolve these issues in the UK. What I want to say about this from the perspective of Britain's museums is that this process is absolutely brilliant because it takes very, very difficult decisions out of the hands of museums and gives it to an independent panel of experts who have no stake in the museum collections whatsoever. And museums can focus on conducting research and communicating this research to their audiences. And Isabel has mentioned that there are 3 objects from the V&A's collections which were restituted. And your question is, of course, how many objects are left? And the honest answer is that nobody knows, because you would have to look at this for every single object. And I would say, and that's how I will end my short presentation, that the biggest challenge for me as a curator at a museum are new acquisitions and incoming loans, where we don't have a lot of time to conduct this research. And the stakes are very high because the museum risks purchasing an object which it might have to restitute. It risks losing the money involved in this. And there's the real risk of damage to the museum's reputation. So thank you very much.
Jacques, thank you very much. And firstly, I didn't have the opportunity and missed the opportunity to explain to everybody Jacques' great experience in this area, because Jacques is the Rosalind and Arthur Gilbert Provenance and Spoliation Curator at the V&A. So this is absolutely what he's doing from the institutional aspect. Jacques is a member of the National Museum Directors Council Spoliation Working Group, which coordinates these provenance research efforts between UK museums in this area, as well as having actually experience with, should we say, parallel processes into colonial era artifacts, which we're not talking about today, but there is a parallel conversation there. The other thing I wanted to point out was actually that Jacques had co-curated the Concealed Histories Uncovering the Story of Nazi Looting exhibition, which I think was the first ever exhibition about provenance in a UK museum. Pretty groundbreaking to actually have an exhibition to talk about these issues rather than directly about the objects themselves. I think it's an indication of how things are moving on in this area, and members of our panel are very central to that. And on that note, we will move to our final panelists. His Honour Judge Tony Baumgartner, who is Deputy Chair of the UK Spoliation Advisory Panel, the panel that Jacques referred to just now. This is the panel that's formed under the Washington Principles. Isabel mentioned that about 5 countries had set up these panels. This is the UK's one, and it's tasked with resolving claims from people or their heirs who have lost possession of cultural property during the Nazi era, and that property has turned up in UK national collections. Tony Gaartner is also a circuit judge sitting in the London courts and is a former partner of the international firm of solicitors Clyde & Co, headquartered in London. Tony, over to you. Over to you.
Thanks for that introduction, Tom. Well, we've heard mention about the Washington Principles. They remain principles rather than binding obligations on the many countries that have signed up to them, but they don't reflect the effect that a treaty would have as between nations. There's no legal effect. There's no responsibility on the signatories to transpose the principles into their own domestic law. The real risk, of course, in not following them, if you are a signatory, is the risk of becoming an international pariah for saying you do something when you don't. The principles seek to provide a solution for a moral problem and to provide redress to victims within our living memory. And I think that is one of the driving reasons for dealing with claims of this sort in a way that is different to other claims for cultural property. That redress, of course, is the return to their rightful owners of cultural objects confiscated by the Nazis outside of legal norms that would now scupper those sorts of claims. I want to tell you about how the United Kingdom has given effect to the principles through the Spoliation Advisory Panel once the gaps in provenance that have been identified by Isabel and Jacques have been filled and victims have been identified. The story starts well before 1998 in a declaration made by Allied governments here in London in 1943. In this declaration, the Allies set out the ground rules for their response to looting in German-occupied countries. The reach into Germany itself to undo the Nazis' work there would have to wait until the military occupation of Germany after its surrender. But the declaration set the tone for what was to follow. In the declaration, the Allied parties reserved the right to declare invalid transfers of or dealings with property during the period of German occupation or control of territories in question. The wording of the declaration covered all forms of looting to which the Germans had resorted, and it applied, for example, to the stealing or forced purchase of works of art, just as much as to the theft or forced transfer of bearer bonds. We know of the work of the monuments men to return displaced cultural objects to their country of origin in the immediate aftermaths of the war. But throughout the post-war period, it became increasingly clear that many works of art, as well as other types of valuables and religious objects, had never been restored to their original owners after the war. There were many reasons, but the main one was the hurdles that had been thrown up by the law itself through the operation of statutes of limitation, as Tom has already referred to. There were a series of international conferences held to address the problem, And the most prominent is the one that you've already heard reference to, the Washington Conference in 1998, where the Washington Principles emerged as a set of non-binding guidelines to assist in resolving issues relating to Nazi confiscated art. Isabel's already mentioned some of the principles, but some of them are worth repeating here, including Principle 2, which says that records and archives should be open and accessible to researchers. Principle 4, which says that unavoidable gaps or ambiguities in provenance should be considered in light of the passage of time and the circumstances of the Holocaust era. And importantly, Principles 8 and 9, which say that where art is found to have been confiscated by the Nazis, steps should be taken to achieve what's referred to as a just and fair solution. So in the immediate aftermath of the Washington Conference, the British government put together the Spoliation Advisory Panel with a retired English Court of Appeal judge, Sir David Hurst, as its first chair. In fact, the panel's terms of reference are much wider than the principles require. The panel is able to consider claims from anyone or from any one or more of their heirs who lost possession of a cultural object during the Nazi era, between 1933 and 1945, where such an object is now in the possession of a UK national collection or another UK museum or gallery established for the public benefit. The purpose remains the same as the principles, that is to achieve a solution which is fair and just, both to the claimant and to the institution. In fact, the panel's terms of reference make that its paramount purpose. So, notably, the panel's terms make no reference to the Holocaust era, sometimes confined to only 1941 to 1945 and the years immediately surrounding those. Instead, the panel's terms of reference refer to the much wider period from when the Nazis took power in Germany in January 1933, right through to the end of 1945. Of further note in the panel's terms is the lack of any need for the object to have been confiscated. It simply has to have been lost in the Nazi era. So that's led to the panel considering claims where there was neither a Jewish person nor a Nazi in sight, like the claim for the Beneventan Missal, said to have been taken from the chapter library after the city of Benevento was bombed in 1943 and turned up here in London in 1946 and later acquired by the British Museum. Also of note in the panel's terms is the way in which claimants are encouraged to frame requests for the return of objects on moral grounds rather than purely relying on legal rights. Now, these grounds can include the moral strength of the claimant's case based on the circumstances in which the object was lost, as well as any moral obligation which rests with the institution. The panel can recommend the object's return to the claimant or the payment of compensation or even an ex gratia payment. But when monetary payments are made and the institution retains the object, the panel can also recommend that a notice recounting the object's Nazi-era history can be placed next to it. The primary remedy given now is restitution. Until recent times, there were statutory constraints on public institutions' abilities to dispose of objects from their collections. And Section 5 of the British Museum Act 1963 is a good example. That allows only for the museum to dispose of an object if it's a duplicate, or if it was made before 1850 and is printed matter, or if in the opinion of the trustees, the object is unfit to be retained in the collections of the museum and can be disposed of without detriment to the interests of students. Any condition attached to a gift or bequest to the museum, however, must be observed. And obviously, these laws create a barrier to restitution, and one that was not overcome until our Parliament here passed a law in 2009, which allowed the return of objects where the panel had made a recommendation for return. That didn't stop people trying ingenious attempts to try and get around the statutory constraints on disposal. And one such case was the Attorney General and the trustees of the British Museum, a case from 2005, which was argued in the Chancery Division here. The museum sought to use the Charities Act to get over the Section 5 hurdle because the trustees felt morally obliged to return 4 old master drawings that had been taken by the Gestapo at Brno from the Czech lawyer and collector Dr. Arthur Feldman. Sir Andrew Morritt, who was the Vice-Chancellor who heard the case, said that the museum could not invoke the Charities Act to override the very clear statutory prohibition on disposal in Section 5. The law which changed things for cultural objects lost in the Nazi era, the 2009 Holocaust Return of Cultural Objects Act, still prevents the disposal of an object which is subject to a trust or to a condition that would prevent its transfer. And in addition, the Secretary of State must also approve the panel's recommendation, but there's not been a case where he or she is not. The panel's claims process is for objects only in UK national collections. The terms of reference do allow us to offer non-binding advice on claims for objects in private collections, where both the claimant and the private owner agree. But we've not yet had anyone take us up on that, which is perhaps surprising given our advice costs nothing to seek. The panel's made up of a very broad church of people. There are, as one would expect, some lawyers. There's me, there's a retired Lord Justice of Appeal from Northern Ireland and a retired Lord Justice of Appeal from England. There's also one of the leading historians of the period, museums directors, dealers, academics, and even a moral philosopher. You can find the panel's reports on the gov.uk website, and in them you'll find a narrative of how we've gone about considering questions of legal title and assessing the moral strength of a claim. Some legal commentators have tried to distill a consistent pattern of reasoning and outcome across our reports, but I think that is a very difficult task given so many of the claims turn on their own particular facts. Well, that's pretty much a potted summary of the panel and its work. And as Tom said, I'd be happy to take questions later on, but back to you, Tom.
Tony, thank you very much. Gosh, that was a whistle-stop tour of everything the panel does. I picked up actually one thing that I wouldn't mind sort of going back to, and that is you pulled out Principle 4, given that we've got a lot of lawyers in the audience, talking about the unavoidable gaps or ambiguities in the provenance. One could read that both ways, but presumably this is a opening the door to a claimant rather than closing it by supporting a defendant. Usually you would say, I own this, I possess it. If you can't prove, if you haven't got a full provenance to prove that you can take it from me, then I keep it. Whereas Principle 4 seems to be turning that on its head and saying, if there are gaps, this is why there are gaps. They're unavoidable and understandable. They should not be a bar to pursuing your claim.
That's right. And I think it's simply to reflect the fact that the documentation that people would normally otherwise be able to produce, it was lost or destroyed, or simply, people may not have kept things in the way that they might keep them now, and records may not remain. And for that reason, and as Arthur has already pointed out, in these sorts of claims processes, the panels are very, very...
You've just gone muted. Go back.
There we go. The panel's very understanding of the reasons why those sorts of gaps in provenance may be there, and for the very same reasons we accept evidence such as a photograph with the object in the background, which forgers have also sort of taken
exactly
as well. But there are also it's something that needs to be established on the balance of probabilities, and we accept all sorts of evidence to help the claimant discharge that burden.
And presumably that's why it's almost impossible to create a sort of precedent bank of previous decisions, because they're going to be so different.
Absolutely.
And the apologies for my clock, so different, and the evidence that you're looking at will be so different, or the absence of evidence.
That's absolutely right.
I think certainly in disputes I've been involved in, I think lawyers actually tend to find that more challenging than other people. I think we're used to fact-driven, evidence-driven cases which can be compared in a fairly granular way, and in these sort of cases that just isn't possible. It seems to be principle 4 is making that point, that it's a very different game. Turning to Isabel, if I may, for a second, because I want to think a little bit about these disputes coming up in the marketplace rather than in. So we have two types of disputes that we've seen here. One type is a sort of institutional response, where it might be easier to see the moral imperative, even if there's there are legal obstacles, as Tony described. But in a market instance where you have an owner who's an innocent owner, who's at some point presumably paid good money for this object and therefore feels that they have both possession and rightful ownership, and a claimant, for all the reasons that we've talked about, feels they have a very strong moral claim to that. Isabel, what would you say is the main driver for people to actually engage with each other in resolving that in the first place? What brings them to the table?
Well, you mean what can be motivations for private collectors to do provenance research? Is it that?
Or more? Well, I was thinking more. I was coming to that later. I was thinking more in terms of if a private collector is the rightful legal owner of an object that they have acquired in good faith, should we say, some time ago, and in circumstances where it may not have been possible for them to have discovered that object's provenance. What brings them to the table to address a claim from an individual who is quite obviously time barred and doesn't have an obvious legal claim? And yet people do come to the table. Why do you think that is?
Well, I mean, that is because if you, this was, for example, well, that was one of my examples, the silver cup, for example, because I mean, in my case, for my client, at the moment, he has no intention to sell, but he, for example, in this case, he wanted to clear his collection for the next generation, and either you do it now, and yeah, and I mean here it was my client who was the good faith purchaser of this piece and other pieces, or you pass it on to the next generation, because if you don't try to resolve these cases, then there's not much you can do with your objects. You cannot even give them to an exhibition at the moment. But I have to say that these cases are extremely unsatisfactory for private collectors, because, as you said, they in many cases they paid a good price for these items, and they acted in good faith, because like with this cup, the registration took place only 2 years after the purchase at TEFAF. And I mean, in this case, my client decided not to go back to the seller, to the gallery who sold it to him in 2009. The problem here was also that the gallery doesn't exist anymore. But I mean, even if the gallery would have existed, I'm not sure if they would have turned to them, because I think it would again have been a very lengthy and also difficult process, and with an uncertain result. And so, I mean, there are discussions in Germany at the moment to create a fund, for example, where private collectors could turn to, where the government should also contribute funds to help private collectors to deal with such situations.
That's very interesting. So a fund, so using public money to compensate private owners where presumably they suffer a complete loss if they've decided for whatever reason to return the restituted object. I mean, the cases I've been involved in generally involve a sale, which gives one a huge advantage, and assuming the value has gone up, you can share the sale proceeds. But the more difficult ones are always when either one party says, I don't want to sell the object, it's the object I particularly wish to have rather than its value. That they're much harder to settle, because in those cases you have a winner and a loser, and with no legal rights to apply, you've got to try and find a settlement where there is 100% winner or user. So I'm interested in this fund. I don't know of a case in or a similar fund in any other country. I don't know if the other panelists.
It doesn't exist. I mean, it's one of these ideas.
It's a proposal. Yeah,
it's a proposal, but it's not very concrete yet.
It's always subject to the money, but if one could fund it, one could see that as being enormously helpful. I have a linked question, and this goes back again to this point number 4, principle number 4, about absence and gaps in the provenance. So it's a question to all our panelists, really, and I'll start with Jacques, I think. When do you stop? You're you're searching the provenance, you're researching, at what point do you decide that you've looked everywhere and you've found all that you're going to find?
So that's a very good question, and the honest answer is that you try to get as far as you can, and then you focus on the objects where you've made some progress, and then you sort of return to the other objects, maybe when you had a brilliant idea randomly for another research avenue. But the reality is that gaps are real, and it is very, very difficult to close them. And what I thought was quite interesting is how the perspective on gaps has changed, where in the past they weren't seen as a problem, and then in the 1990s, when British museums presented their research to journalists at a press conference at the V&A, and the museum said we have thousands of objects with gaps in their provenance, the journalists then wrote stories that said if an object has a gap, it's very likely that it was looted, which sort of had a profoundly negative effect on provenance research activities at museums, because they realized, okay, we were trying to do the right thing, we are open and transparent about the gaps, and all we get is this negative publicity. And I think it's one of the big challenges to explain that a gap in itself is not necessarily indicative of problems, especially if you're dealing with a lot of the objects that we have at the V&A, where it's not sort of impressionist paintings or anything like that, but it's sort of smaller objects, everyday objects, pieces of furniture, smaller silver items, and so on. So, but it is very, very difficult and unsettling in a way that it is impossible in many cases to close this gap. And because there's no definitive list of all the objects that were looted by the Nazis, we probably never will be able to close.
And of course, that's one thing if an institution is in control of its timetable, because it's reviewing its own collection, and the same would go for Isabel advising a private collector. You're in control of the timetable. But if you're in the market, or if you're considering an acquisition for the institution, you are up against, there is a hard stop at a moment by which you have to make a yes or no decision.
Absolutely, and they're big. The big auction houses, of course, have brilliant restitution departments, and you can have a lot of confidence as a museum if you buy from them. But a museum like the V&A, when it has money to acquire new pieces, often acquires them from small auction houses where gaps or non-existent provenance information is the norm. It's not the exception, it's absolutely the norm, at least for the type of objects that we acquire. And they know that they will be able to sell the piece because there will be someone who is able to bid more than a museum. So why go through all this trouble, contact the consignor who then gets scared because they think somebody is implying that the piece was looted. So it can be very difficult. And often we only learn about an object 4 days prior to the auction. And my attitude towards this is that it is better if it ends up in a museum than in a private collection, because if it comes to a museum, then at least we are able to restitute it. And if the value is not enormous, then it's sort of a loss that the museum can stop. If we're talking about sort of a small portrait miniature for £2,000, maybe it's a loss that a museum can stomach. Whereas otherwise it would just disappear in a private collection, which, as Isabel explained,
and I think that makes a point that we should all remember, and that is that one tends to focus on the object's worth hundreds of thousands or millions of pounds, but actually the volume of most of these works are not hugely valuable individual objects. They are much less valuable, much less unique objects. But going to Arthur's point right at the start of this session, they could nevertheless be of extreme importance in a wider way to the claimant, but will have left often no track, no historical track as they've passed. So there really isn't, I mean, we may not be talking about a small gap, we may be talking about a very large gap in the provenance. So yes, if it came before Tony, it would be very difficult, would it not, to establish. I mean, have you had cases where there's been very little evidence at all?
There is, and I think that goes to the weakness of the claim, because if you can't properly establish on the balance of probabilities that it was within your possession at some time, and at the time that it was lost, then you don't really get off on any foot. So that is why the provenance research is so important, and finding out exactly where an object came from, what happened to it, and where it ended up is fundamental in any dossier of evidence that gets put before the panel.
And I mean, that sort of leads to the possibilities of appeals and such like. Arthur, I was wondering, you mentioned that there was a very effective appeals process for claims for financial claims, insurance claims. I wonder if you could tell us a little bit more about that. Arthur, are you there? No, possibly not. I think maybe a storm has blown the tree down for Arthur. I think we've lost him temporarily. Can you hear us? No, I think we've lost Arthur temporarily. Hopefully we'll see him soon. Isabel, looking at the timeline of this, obviously Washington 1998, non-binding principles, as we've heard. Arthur, I'll come back to you in a minute. 1998, could you give us a feel for how these claims are running in the marketplace? So between individuals, was there a great spurt after 1998, or was it some years later? And is that continuing or is that declining in your experience?
From my experience, I would say it's continuing, and it's getting more, because more and more documents are being available, which is leading to more claims, which is at the same time also a problem, because you might have thought with some of your cases you have resolved them on the basis that there was no more evidence, and then some years later something could turn up again, and not everyone if it's in a museum, like Jacques just said, then you might be in the position to give it back, but if it's in a private collection, then you lost track. And so no, my feeling is that it's getting more, and there's also more like ground research being done, so you can more context research, so that and also more family archives are being accessed, more researchers are looking into them. So there, it's really, when I started 20 years ago, I thought maybe I need to look for something else after 10 years, but it seems as if it's really going on, and it will go on for a while. And we were also looking at other categories of problematic objects now. And for example, also objects which were wrongly dispossessed during the GDR times in Germany, for example, or colonial loot and so on. And this is not our topic today, but I would say it's really a growing field still.
And would you say that, specifically on this topic, that you mentioned information is still becoming available? I think we know that quite a lot of information became available with the fall of the Berlin Wall, and records from wartime records that had not been available before that. In what ways is information becoming available now?
Well, I mean, you have, for example, through digitalization, that is a very important point, because this makes information available, for example, for heirs looking for their looted items. I mean, this only applies, of course, for public archives, for example, or museums, not for private collections, but I think this is a very important step that is being taken. And also our research is sometimes worldwide. I mean, you don't know in which geographical context a case might bring you. So being able to get documents, for example, from other countries, which are now in a digital format is becoming much easier and is also helping with research.
Quite. Thank you.
And also, but also, sorry, also geographically, more research, more archives are becoming accessible. For example, in Eastern Europe, that has also changed in the last 20 years.
Yes. Yeah. Arthur, welcome back. We were talking about appeals earlier on, and this Isabel's point rather leads to it, because as information comes out, it seems to me that previous decisions may be reviewed, and even possibly previous settlement agreements or failed settlement agreements may come under review. You mentioned at the beginning that there was a very effective appeals process run by the UK. Would you like to give us a little bit more information of how that works?
Yes, can you hear me now?
We can, clear as a bell.
Okay, good. The appeal process works in this way. We have an appeal adjudicator who is always a senior lawyer. We have had 2 retired Court of Appeal judges acting in that capacity. And they have an unusual role, because when an appeal is made, it's usually on the basis that the dissatisfied claimant says, now I really understand what the panel of arbitrators needs, and that person will provide additional information. The appeals adjudicator examines that extra information. He then doesn't make a decision himself, but if he feels it has merit, he returns it to the panel of arbitrators for reconsideration. And usually that extra piece of information assists in changing the verdict. Sometimes it doesn't. One interesting example is there was one claim several years ago that was turned down, and it was also turned down by the adjudicator on the basis that it had no merit, and it didn't come back to the panel. But more than 10 years afterwards, the original claimants came back with a new piece of information that they had unearthed, and it led to a reversal of the situation. So that's an example of how we're very relaxed in trying to help claimants make their claim legitimate if they're able to do so. And the passage of time didn't stop that happening in this.
That's very interesting, thank you. I mean, it seems to be that it's one thing to do that when you have an institutional process and you're effectively releasing institutional funds of one form or another. It's more challenging to see how that works with settlements between individuals. When you're talking about title and ownership and possession of an object against what may be seen as a movable feast in terms of information becoming available later on. I think that's going to be a challenge going forward. I'm just going to have a quick look at the chat box, because I'm assuming that's where we may have some. Can I just skim down, unless Tony Connerty has been looking through it. So we have a question from OSO to all panelists. Is it really true that legal issues were the main reason for the sluggish return of works in the post-war period? The Allies themselves threatened in 1943 that they would annul all transactions by persecuted persons and thus remove the legal obstacles. Who would like to comment on that? So is it the legal, well, I think there's sort of 2 points in there. One, was it legal issues being the main bar in the early years rather than the later years? And secondly, this threat in 1943 that I must say I didn't know about, to annul all transactions by persecuted persons.
I think the 1943 reference is to the London Declaration.
Right.
Olaf is quite right in saying that that was the revealed intention of the Allies at that time. But I think what the Allies did at the very end was, when they handed these objects back, they relied on the domestic legislation or the domestic position to perfect what their stated intention was. So it may be, and we know, for example, in France and in places like the Netherlands, that objects that were returned by the monuments men, that where they couldn't be returned, or no original owner could be traced, they were simply left in collections, and there they lingered for many years, and I'm afraid sometimes still linger. So he's right in a way, but to look a little bit further on, and that is when, as you've said, Tom, the limitation periods and doctrines like Laches come in and prevented people from claiming. And some people just didn't know how to go about making a claim, because they thought, well, and Simon Goodman's book, The Orpheus Clock, he recounts very painfully how often his dad would go and look at material in galleries, and note that it was in his family, and what could one do about it? I think he was compiling dossiers trying to prove the provenance of it and establish that they were the true owners. But until you get over that hurdle of being able to satisfy the burden of demonstrating it was yours, then you're really left with nothing else to go on.
Indeed. Evidence, provenance research being absolutely key, both then and now. Arthur, I've got a question for you. This concerns the Swiss bank account compensation that you mentioned at the beginning, when you talked about the book value at the time multiplied by 10. And the question is, what was the basis for multiplying the book value by a claim of 10? Was that a random figure, or was there some particular thinking behind it?
The thinking behind it was that it was the long-term investment returns on Swiss investments, and they fixed it at that time, and they hoped, I think, that they would clear all of the claims within a certain period. Of course, the British system is more generous because the inflation continues to go up even to this year.
Thank you. I think that answers the question. We had one other question, which I think we'll deal with later, because I'm not sure I understand it. I'll read it out from Solomon Ezobi again. Hastings and Bexhill Catenians, if there are any doubts and disputes with regard to ownership of objects subject to a claim, how do the panel deciding ownership come to a decision? Well, I think we've sort of covered the issues of how a panel comes to decide that, not by precedent, but by looking at the facts of each case, predicated on at least some evidence that show original ownership of the object, how it was lost, the fact that it was lost inappropriately, should we say, and then a right to to inheritance, effectively nowadays, of that object. But it's very difficult to be more specific than that, because each, as Tony explained, each case is very, very different. Jacques, I was just thinking, is it possible to predict? There have been relatively few claims against UK institutions, and that is despite the UK taking from very early on in this process a stand that such research should take place and claims be made. Why do you think there have been relatively few claims, and what's your, if you look into the future, how do you see that trend running?
I mean, the obvious answer is that because the path taken by the objects was much longer in the case of UK institutions. So right. It's no surprise that German museums, I think, collectively have restituted some 3,000 pieces in the UK, the number is, as you said, very, very small. And I think that's one of the problems, because we measure the success of provenance research in the number of successful restitution claims. Right, sort of, and it has prompted certain colleagues to say, well, if the number is so small, why should we do this research? But I think it should sort of prompt us to have the opposite reaction to this, and to recognize that, because in most cases museums simply do not know an awful lot about the origins of their collections. It's a mandate to conduct more research, and in many cases this research will lead you to the conclusion that the object was looted by under the Nazis, and that it was restituted after the war. And in the past, museums said, okay, right, this is where the story ends. It means it's sort of legally unproblematic. We don't have to restitute it, so let's not talk about it at all. But I think sort of museums, as visitors become more interested in these stories, realize that these are stories that are worth talking about to our visitors. Because one of the things that were discussed at the Washington conference was Holocaust education and the importance of it. And that's something that we tend to forget if we only put a legal lens, legal glasses on, and just look at this in terms of legal problems. The issue is that nobody knows how many claims will follow. Another issue is that, of course, somebody needs to be active. If the museum doesn't know who owned it, then there needs to be somebody actively looking for it, if it's not in our own records. And of course, there's the focus is on a small number of very well publicized collections which were dispersed. The Bootcamp Collection, I mean, this affected multiple institutions, but it's also particularly easy because you have the auction catalog and the case is completely clear cut. But I'm confident enough to say that I'm sure that there are many objects which nobody has on their radar, that nobody is actively looking for. And that museums don't know much about, that have this provenance, and I think it's a mandate for more research.
So it's not going away soon, this issue.
No, I mean, because the
Holocaust for a while.
It won't go away, because now every time a museum buys an object, we want to know more about its provenance for the reasons that I explained, because it would be hugely embarrassing to not do this research today. And the same applies to incoming loans. But all of this is very, very difficult. And Isabel mentioned the databases, and they have the same problem, right? Because somebody needs to actively add data to these databases. Yep. And yeah, so that's.
Excuse me. Well, thank you. It's I noticed actually when you gave your example of one of your provenance sheets, which showed nothing about the previous ownership. It did actually show something, though, that I think is always useful, and that is at least a sign. The example that you'd highlighted was it came from, I think it was Lord Luke at Parham. And that would be a sign that possibly it was not a 1933 to 1945 issue at Parham. I noticed it because Parham's about 100 yards down the road from where I am now.
So this was for a sword which was made in the 15th century. This entry, and
yes. And so that rather sort of shows how this is the provenance research is sometimes almost a sense of smell. You're looking at something with an absence of information. Is the absence likely to be problematic, or is it not? And so you have to make a very early decision. If this came out of Parham House, which is a very large country house with a collection that goes back several hundred years, then you're less worried about a post-1933 gap than if it came from continental Europe, when you have every reason to be more concerned about that gap. So it's an interesting process for lawyers, because you are juggling the lack of evidence sometimes rather than the evidence. And you have a moral imperative to do that, which makes it a very interesting area. I think we've sort of come to the end of our allotted time. So if anybody has any further questions, as I said at the beginning, we will try and address them. If you could put them to the info@idrgroup.global, where we will try and make sure the appropriate person can give you an appropriate answer. If you would like to do some more quick but very reliable research into this subject, I will quickly recommend the second edition of Norman Palmer's Museums and Holocausts book, to which most of this panel has contributed a considerable amount. So it's a very good way of accessing their huge amounts of experience and knowledge on this subject. Panelists, I'd like to thank you very much for being so open and informative and giving your different viewpoints on this huge area. And I hope that everybody else has found this process interesting, thought-provoking, and useful. Anthony.
Tom, many thanks indeed. As you say, that was a fascinating webinar with some really quite extraordinary panelists speaking to us. So on behalf of the IDR group, I'd like to thank you for moderating this webinar and thank our panelists, Arthur, Tony, Isabel and Jacques. Also to thank Dr. Edward Murphy, without whom this series of webinars would never have got off the ground. But a very special thanks to our delegates. The interest in this webinar has been worldwide, and we've had delegates registering from France, Germany, Switzerland, Italy, Sweden, the Netherlands, Poland, Australia, Nigeria, South Africa, Korea, the Republic of Korea, the UAE, the USA and the UK. So very broad interest in this topic. The group is planning further webinars. In particular, the group is planning a second art law webinar later this year. No theme has yet been decided. So if you have any suggestions, then please let us know. The global website has already posted information on this art law webinar and information on the book which Tom's mentioned, the Museums and Holocaust book. That has been published by the Institute of Art and Law. It's the second edition of the late Norman Palmer's book, contains contributions from 3 of our panelists, Judge Tony Baumgartner, Isabel and Jacques, and I think also contributions from a number of our registered delegates. So thank you all again to our panelists, to Tom and to our delegates, and we look forward to seeing you at a future webinar. Thank you very much indeed.